Hello, Professor and peers. My name is Paul Commissar, and my group members in this project are Boris Spinilla, Frank Shung, and Shania McDonald. We visited 2 tribunals. However, this presentation will only cover our research into the Ontario Labour Relations Board. The purpose of the Ontario Labour Relations Board is to resolve complaints and disputes between employers and workers, or their collectively bargaining unions. The board draws its powers and responsibilities from 30 different statutes more or less, and examples of these include the Labor Relations Act, the Employment Standards Act, the Occupational Health and Safety Statute Law Amendment Act. The OLRB was founded in 1948, and some legal historians speculate that some of the factors that came into the creation of this tribunal was the Winnipeg General Strike of 1919 and the rising popularity of socialism due to the explosive successes of the Soviet Union in the years following the end of World War II. Now, bringing history and politics into this board so suddenly might be a cause for alarm for some of you, but allow me to explain how these are all connected. The Winnipeg strikers protested high unemployment, inflation, unsustainably low wages, and many workers were inspired by the successful Russian Revolution only 2 years prior. The strike was a success, and their issues became a platform for future labor reforms in Canada, including the Collective Bargaining Act of 1943 and the Labor Relations Board Act of 1944. In the years during and after World War II, socialism and communism became increasingly popular in Canada. It is reasonable to view the formation of the Ontario Labour Relations Act as a way to appease working-class families and to invalidate some of the criticisms of Canada from the Communist Party of Canada, which had been becoming increasingly popular between the 1940s and 1960s. The reason why I even mention this is that this is more than just an interesting factoid. It helps us understand the principles that were applied in the founding of the board. It not only gives employees the ability to air their grievances with their employer, it allows the employers to respond and reason with their workers. The OLRB has the power and jurisdiction to ensure that this happens in a calm environment where neither has the upper hand, and that real closure can be brought to both parties rather than the purely capitalist approach of the factory owners before the 1920s, or the purely communist views of the CPP after the 1940s. Today, an employee with a grievance against his employer can begin the first steps towards resolving his disputes with his employer by finding and filling out the correct forms to the best of his ability and filing them with the board. Applicants are recommended to read the entire package that comes with the form in order to best inform them of the ways of the board and what to expect. The packages and the rules within them direct parties to complete the forms, explain how and when to deliver whatever materials are needed by the other parties, and how to file the forms with the board. An additional tip the application packages provide is a description of what materials they need to provide immediately and what can be delivered on a later date. Before a hearing is allowed to begin, there is a mandatory short pre-hearing that resembles more of a meeting rather than a hearing. A vice chair uses this as an opportunity to narrow the case to a specific issue or deal with procedural matters. The vice chair may make a ruling to direct parties to do certain things before the next proceeding. As a side note, I found this line to be very interesting. It says that a pre-hearing conference will not normally end with a final decision on an application. This suggests that it sometimes does, possibly on the basis of rejecting an application that holds little or no merit, although neither my peers nor I could find examples of this. After the pre-hearing meeting, a date is set for the hearing if it is still necessary to resolve the dispute. Like the other boards and tribunals, the OLRB has a large library of forms and other paperwork that the general public would consider daunting. However, just like other boards and tribunals, the sheer volume and variety of problems that occur inside the board's niche area of expertise necessitates the amount of forms that the OLRB carries. The board is entitled to determine its own practices and procedures along with the forms, notices, and other paperworks, allowing it to act with some degree of autonomy. Applicants, respondents, and other parties typically follow Part 2, Rule 6 to commence a proceeding. Rule 6.1 states that the proper forms must be completed, delivered, and filed. All necessary documents must also be attached. 6.2 states that parties must also retain original, signed copies of the applications or responses that they make. In our group's case, we attended a hearing about the certification of a trade union. The process begins by the applicant or applicants filing an A1 application for certification and must include evidence of membership, a list of employees in alphabetical order, and a declaration verifying the membership evidence. That declaration is called the A4, or Declaration Verifying Membership Evidence. Membership evidence must be put into writing and signed by each employee involved. As a side note, this can be a long and complicated process when your proposed union exceeds 200 members. Along with this, the applicant must also give a copy of the application, but not the membership evidence, a list of employees, and the declaration to the respondent. Applicants must deliver a blank A2 for responding to a certification application, a Schedule A, which is a list of the employees involved, and a blank Form 124, which is a confirmation of posting. Additionally, the applicant must give a copy of a C1 notice to employer of the application, a copy of information bullets number 1, 3, and 4, and a copy of Part 3 of the Board's Rules of Procedure. Information bulletins are documents that explain large, complicated parts of the practices and procedures within the board's system. These specific bulletins were about certification of trade unions, vote arrangements, and status disputes in certification applications. If the applicant mentions an affected trade union, the applicant must also give the affected parties a copy of the application, a blank copy of the form for intervening in the application, which is an A3, information bulletins 1 to 3, and Part 3 of the Board's Rules of Procedure. A side fact is that the respondent only receives 2 days to file a response. There are quite a few handouts and forms to read and fill out, and I'm not sure, personally, how employers are able to respond in time unless they have already retained legal counsel. Additionally, parties in most matters have the option to file a request of the appointment for an arbitrator to faster reach a collective agreement through an expedited process outlined in Section 49 of the Labor Relations Act. An individual can become an approved arbitrator after filing a Form 6, Decisions of Arbitrator or Arbitration, a Form 7, Declaration by Employer Bargaining Agency/Organization, a Form 8, Declaration by Employee Bargaining Agency/Affiliated Agent, and a Form 9, Board Decision of Arbitration. The decisions of the OLRB are made by the chairman, who are selected by the lieutenant governor. Each matter is heard by at least 3 chairs, 1 leading chair, 1 alternate chair, and at least 1 vice chair. Like most other tribunals, OLRB hearings are generally open to the public unless there are sensitive matters that one or more of the parties do not wish for the public to witness. During our group's hearing, the chair and alternate chair each took responsibility for recording the testimony and evidence of one side of the matter. The vice chair led the hearing. The chairs sit at the front. The chair and the alternate chair sit on the sides and focus on recording the evidence and testimony of each side of the application. The vice chair sits in the middle and leads the proceeding and often is the one who writes the final outcome of the hearing himself. The public observes from the gallery. The employee applicants and their agents sit on the left-hand side of the gallery. The employer respondents are seated to the right. The witness stand is situated between the employee side of the table and the chairs. The center section of the horseshoe-shaped table was vacant during our hearing, and we could find no existing diagrams of the board, hence why I made my own. My group members and I speculate that it might be reserved for third parties, or as extra seating space in cases where there are many applicants or agents attending the hearing. The Ontario Labour Relations Board has the power to grant interim orders under special circumstances. Changes to the 1993 Labour Relations Act provided the OLRB to make substantive interim orders. Over the years, they have gained the power to consider increasingly complicated issues where the applicant seeks interim relief. Examples of these include union recognition, operation of a subcontracting clause, and prohibiting the stopping of work. The board also has the power to make some orders regarding procedural issues. They can reinstate the employment of a worker, order an employer to follow the terms and conditions of employment contracts, and other similar remedies that set the balance of powers between the employer and employee back to the way they were before their issue began. The decisions of the OLRB are final and binding, and no appeals are allowed. Of course, the only thing that is constant in law is exceptions. The board can be convinced to reconsider their decision if a party submits new evidence that would likely influence the outcome of the hearing. The catch is that parties are not allowed to repeat the same evidence or arguments from the previous hearing. The other exception is that a party can apply for judicial review, where the matter will be brought to the divisional court. However, the divisional court will only review the board's decision for its reasonableness, rather than conduct an entirely new hearing. There was a time in 2013 when a Parliament member attempted to amend the Labour Relations Act in a way that would affect the OLRB in this area. There is a short clip on YouTube where he made a proposal in Parliament. Please excuse me for a minute while I pull it up. The man in this video is Progressive Conservative Member of Provincial Parliament, Randy Hillier. He said that his changes from Bill 63 would allow applicants and respondents to appeal OLRB decisions to the divisional court for an entirely new hearing, in addition to making ministry officials compellable witnesses before the court or tribunal. In order to do this, he would remove or strike down the stated purpose of the Labour Relations Act, where appeals are expressly prohibited, and provide new meaning on top of it. Boris went to the Ontario Labour Relations Board on the third floor of 505 University Avenue. Before the hearing began, he met with the counsel for the employee applicants, who briefly explains the purpose of this hearing, some terminology of the board, and a few of the common practices and procedures of the board. These are some of the things that Boris learnt before the hearing. A dissent to an order is a motion where the individual would like to express an alternate point of view or to present a position on the laws, facts, or rules used in the hearing. A representative should only use this if he or she has a valid point to raise. 15 laborers in a work unit is the minimum requirement in order to form a trade union. Government employees are barred from joining trade unions. Instead, they receive their own workers' unions called statutory unions. These workers file applications to the Federal Labor Board. The goal of virtually all OLRB hearings are for the parties to resolve issues in a way that promotes long-lasting harmony. One chair serves the interest of each party, while the vice chair or chairs break stalemates by issuing final orders if the parties do not settle. After this, Boris seated himself and began to take notes. Chairman Nielsen and Zacher represented the employees' and employers' interests. Chairman Wilson was the vice chairman in this matter. The employee applicants were represented by Mr. Bakazi, and the employer was represented by Ms. Malkin. The employer and employees operate Clean Harbors Company, and they provide industrial cleaning services. Examples of the services they provide are cleaning hazardous waste, oil, gas, and chemical packing. In this hearing, the employees of Clean Harbors applied for the certification of a trade union. Boris did not arrive on the first day of the hearing, and so he began his note-taking during the cross-examination of a witness for the respondent lawyer named Paul. He began to copy a transcript of the questioning of the witness Paul by the applicant's counsel, Mr. Bakazi. By the end of the cross-examination of Paul by Mr. Bakazi and the re-examination by Ms. Malkin, Boris deduced that the employer witness, Paul, was one of the designated supervisors of Clean Harbors. Paul, despite only being employed by Clean Harbors for a year and a half, is a diligent and trusted middle management employee. While the chairs did not care much for the objections made by either counsel, they frequently interrupted their cross-examination and re-examination to direct counsel to ask questions about specific topics, or to stop certain lines of questioning, such as hypothetical situations. After re-examination, Vice Chairman Wilson dismissed the witness and Ms. Malkin asked for a 2-day adjournment in order to gather evidence from an out-of-court witness. The Vice Chairman called for a recess, and Ms. Malkin spoke with her supervisor on the phone. Her supervisor granted her the option to settle with the employee counsel. The settlement discussion occurred in private. We learnt what the Ontario Labour Relations Board is. We learnt about its history and how it shaped the principles of the board. We learnt the rules of how one can begin the process to apply for an OLRB hearing. We went step by step on what forms are filed on both sides of an application to certify a trade union. We glossed over the structure of the board and what an OLRB hearing room looks like. We discussed what powers the board has through the remedies it can order. We established that there are limited methods to make the board reconsider a decision or allow judicial review to the divisional court. We learnt that there was an attempt to amend the Labor Relations Act to make appeals more accessible to employers and employees. We can apply the research that we conducted into the hearing to deduce exactly what happened in the weeks prior to the hearing, the mindset of each chairman coming into the hearing, and why they hold those principles, and predict the possible outcomes of this matter if the settlement talks fail. In conclusion, this assignment was an eye-opening first-time experience witnessing the sheer volume of rules, forms, practices, and procedures that make up the very niche field of a single tribunal. My peers Frank, Shania, Boris, and I would like to thank Professor Aaron for allowing us to submit a video presentation rather than a live presentation for this assignment. And both these handouts and our YouTube video will be posted on the Humber Paralegal Facebook group later today. Thank you for lending me your ears today, and good luck to those remaining groups who are presenting.